we reconvened in the hearing dealing with natural hazards, and we're moving on now to hear some legal advice from Council's advisor and then other people. And so really just to set the scene in terms of what we were exploring yesterday, and we have received supplementary evidence that for the area that is shown in the proposed district plan as notified, it's proposed that consent is required for new buildings within the flood affected area. And for the land on the subject to protection from the flood bank, it would be a non-complying activity as the advice for sensitive activities such as residential within the flood area, and restricted discretionary and others. So there was a mix that was being talked about, and you're going to correct me on that, are you?
The 42A doesn't recommend that.
In terms of the...
in terms of the approach for the activity status in the stock bank protection area. It would
so
be
your supplementary evidence?
My supplementary evidence should be consistent with that, yeah. Certainly that is what ES is advancing, yes.
So if we have a look at what was presented yesterday, the recommended amendments to that.
Yeah, attachment A to my evidence?
Yes,
yeah.
Yes. So the status of construction of new buildings, including conversion for sensitive areas within the stockback protection area, restricted discretionary?
Yes.
Yes,
yeah.
Yes. And non-compliance with that is non-compliant?
Yes, correct.
So that's the point that I was getting to.
Yeah.
So that was in the area that was notified in the proposed plan.
Yes.
And that hasn't changed. So the evidence that we had yesterday from Environment Southland in producing plans, and also from Tonkin and Taylor that we've had in previous reports, the areas that they're talking about is pretty close to the same boundaries as what's shown in the notified plan. And rather than having a blanket control over the entire area, what is in the submissions is that there be the degree of risk be looked at. Marcus or Environment Southland has not produced detailed rules, but it is quite possible that what has been promoted by Environment Southland actually fits within and is a reduction potentially of the recommended from the planners. So there's some interesting little twists or issues that arise from that, particularly in relation to scope. And your initial advice to us was based on information at the time, and I'm just wondering, in terms of what's transpired from yesterday, whether the advice you're going to give us is going to be any different.
Thank you. So that accords with my understanding, but please correct me if at any time I say something which isn't quite marrying up with the discussion yesterday. Just pausing to thank the panel and the hearing team for wrangling things because of my unavailability. I will try to be much more straightforward for the next hearing. So at the outset, I just observe Ms. Patterson from ES yesterday. I understand she recommended that the new ES modelling should be used by this panel and by GDC as much as possible through the current process. And I am here particularly to speak about how much that model can actually be incorporated in that process. And I do have some views on that, including in relation to what I've called the option 2 approach, which I think is the one that you summarised just now, Commissioner. In my submission, the Section 42A proposal has responded to, and carefully responded to, the ES information as much as it can in the current process, and I would submit that the panel should be cautious in turning away from that and I'll work through in my submissions some of the implications that I've considered. So turning to my legal submissions, have you had a chance to read those? I haven't given you the summary of the case law. You've heard it a number of times before. I don't think we differ from ES in terms of the broad scale principles. I would note, in terms of scope, there is considering a scope in terms of an umbrella general scope. So we have that sort of general perspective on this is a bit less or a bit more, and then there's also the questions of whether or not particular provisions are in scope. And I think one of the issues that I deal with is the particular change to the maps, which is effectively akin to a rule change. In my submission, there isn't scope as a result of the submission and the way that it was summarised in the summary. Just turning to paragraph 5 of my submissions, I say there, because no mapping was provided with the ES submission, and because they did not explicitly seek an amendment to the mapped extent of the hazard area, it is submitted there is insufficient information in that submission to sufficiently notify members of the community and or affected landowners of the potential extent of any change to the notified plan maps that was sought. So in my submission, that is not just the boundaries of the mapped extent, it's also if there's a substantial change in the way that mapping is to apply. I would observe as well that the mapping that ES has provided yesterday is not comprehensive for the full district. So I just query whether or not if there is a mapped layer which is for parts, there may be some persons reading the plan who would think that was a comprehensive mapping, in which case they would think there were no issues for their property. But clearly that's not the case in terms of the understanding of how these provisions are supposed to apply outside those specifically updated mapped areas by ES. I refer at paragraph 6 of my submissions to the summary of the Regional Council's only submission point concerning the PDP hazards map, and in particular I refer to the decision requested that doesn't talk about amendment to mapping. So I would say that that is a relevant consideration, and it is a relevant consideration in terms of that specific amendment. So moving away from that umbrella approach, which is also very much a perspective that you should be taking into account when you consider scope, I would also encourage you to take that more detailed approach when considering particular amendments, and in this case I'm submitting that more focused view in terms of mapped changes to maps doesn't provide scope here. I am very mindful as well of that notice issue, and that plays out not just in terms of the submission, it also plays out in terms of this process. So the 42A report has nothing in it about changes to maps. That's because those maps were not available at that time to the public. So even if a member of the public or a submitter was interested in this topic and they were following the process, as at the date of publication of the Section 42A report, they still had no notice of the maps or what how those maps might have implications for themselves, their properties, their businesses. So there is a notice issue here. The notice issue continues with respect until yesterday. And even now, I'm not sure the maps are available online. So if someone is following this process, whether they are one of the 30 submitters on the chapter or one of the 4 or 5 who have turned up today, they are not addressing the ES proposal. We heard from the telcos this morning, we heard from Alliance. They have not addressed the ES proposal. So in terms of process and notice of the proposed amendments, I would submit that there is insufficient notice for this panel to run with the proposal in perhaps the robust way that ES is seeking you do. My submission at paragraph 9 relates to the fact that I consider the plan maps carry a special nature in terms of how district plans apply. For me, and I don't claim to be an expert planner, I do head to the maps pretty quickly in terms of seeing the how things apply. So I do think that they carry a particular import for people checking to see how a district plan applies. So when people were checking the notified plan and looking at the submissions, I would suggest that those maps do carry quite a lot of importance in terms of checking whether or not that's relevant to your property or your interests. At paragraph 10, I just endorse and accept the position put forward by ES that the RMA and the regional policy statement require further steps to be taken by council in response to good information. So absolutely endorse that and discuss the variation option. I do submit that the information available today is not robust enough or appropriate to provide this panel with the tools to move forward with the response that ES is seeking. You are looking at a 10-year management timeframe. We are looking at partial maps and no drafted provisions. So I would submit that the proposal in the Section 42A report is robust and is appropriate, mindful also that the indication of Mr. Roy was that comprehensive mapping for the district is intended to be undertaken later this year and in early 26. Sorry, just forgetting the year. And that is the appropriate time for everyone to sit down, consult, discuss, including with the community on how those maps are to be translated into a potential variation. In terms of the regional council timeframes for their own policy statement progress, I understand that sits a little bit closer to where they're heading with amendments to a review of the policy statement. So I would endorse the fact that the council, all councils, will be in a much stronger position to provide a robust and appropriate response when that comprehensive mapping is available later this year. And that also takes account in particular of impacts on private property rights and a need for full and clear notice of all affected landowners and members of the community. I think the rest...
With earthworks, can we come back to that and deal with the hazards first and then come back to earthworks?
So I just, my notes from here, I don't need to deal with the final paragraphs under the natural hazards heading, but I've got a summary, and it may be completely accurate or not, of our options. So what I understand is option one, what I've called option one, is the Section 42A report proposal, which in my submission is a robust response to the ES information that's become available. Probably just pausing and considering that, understanding that the information continues to be developed. There are alternative options for council in terms of ensuring that information is provided. So it is common for district plans to cross-reference and refer people on to a regional council for that most up-to-date and accurate information, and that is one of the tools that Mr. Osborne uses. I would also note that there is an obligation on GDC to ensure that information is notified to the community in appropriate ways, and some of those ways include LIMS and PIMS. I understand an information layer was potentially discussed yesterday. My initial comment on that would be that it may be difficult to use in a way that provides for adequate flexibility for ongoing progress of information, because the change to that information layer would still require a full plan process. And so when, for example, if in terms of the modelling available, or the mapped modelling available yesterday from ES, if that went in as an information layer, say we had another one, we'd still have to commence a plan process to add that in. And then if it was developed further, it would then have to be amended again at a later date.
So I think we had different advice on information layers when we did the archaeological historic heritage hearing and had that conversation around the archaeological alert layer. So it's probably, it could, I was thinking when that came up yesterday that it would be something similar to the information layers that are already sitting in the GIS drop down. So they're not in the plan itself, but they're available for anybody wanting to understand information that's available to inform decisions. What I was wondering as you were just speaking was, when I'm looking at the matters of discretion, for instance, if the key thing is that activity classification, which is I think the thrust of what you're saying, is that activity classification can't shift from restricted discretionary to non-complying based on new mapping. For areas within, or maybe some areas within the stop bank protection area. I think that's really fine-tuning what we are talking about. And so that being the case, then we look at the crafted restricted discretionary rule in Appendix A. And for me, something that might obviously be missing in the matters for discretion is simply use of the best available information. Now imagine if you had a matter of discretion that said use of the best available information, and you had an alert layer that was literally just an information layer, an alert layer, but it's available on the GIS mapping as with other things like the Transpower route and the archaeological sites. That then people could understand what that best available information was. I guess something along those lines. I guess what we're trying to do is ensure that the best available information that we know exists for Gore and Mataura has a clear avenue through the rules. If we can't be shifting activity classification, which is the main pivot point that I can see, you know, is this another way that we can do our best for the people of this district now? Yeah.
So two things. In terms of your point about the activity classification, I think that is predicated on a change to the mapping. So the first step is to consider scope to change the mapping, and that's what I'm saying, that there is no scope to do. And then the flow-on consequence from that is to then consider what's being proposed in terms of, okay, well, if our maps are changed, which I say is outside scope, setting that aside, what are the provisions that we're looking at? And for me, that's a step further, again, in terms of consequences of the change to mapping. So where I have concerns about scope for mapping changes, I have further concerns in terms of a proposal that includes new provisions to respond to that alternative mapping. So I take the panel's point in terms of the maps that are available today and similar boundaries. For myself, if I was the one property that was captured by the new map, I would still find that as a significant concern. All of a sudden I'm inside. And there are maybe people that have scrutinised that issue and said, I'm outside that, it's fine, and then I'm the one person caught back in. That person has grounds to, you know, I'm not going to look at likelihood of them doing so, but they would have grounds to review the process as a result.
But the plans we've got from Environment Southland in effect do not extend outside what was notified.
And that's my submission around the maps.
Okay.
And then,
now, can I just go back to one point?
Can I just finish off that point in terms of the proposal to extend the mapping then somewhere further by some further work that Tonkin and Taylor might do? We don't even have those maps yet. They're not at a fine-grained level for us to even see whether how they relate to the notified maps. So I just want to flag that as my other point.
So there's a couple of issues that arise from that, probably the first one is we've probably got conflicting advice. So clarification. If there is an information layer, can a rule relate to that information layer?
So that was the second point I wanted to come to in response to the comments that you'd made. And I think I need to spend some time considering information layers and how they sit. I did not understand that and it may have been a misunderstanding for me, that the archaeological sites would trigger a rule. No. So, and that's...
No, and neither would this. So I'm not suggesting, just follow me for a moment. I'm not suggesting that, if we accept the position that you've given us, which is what I'm doing, and then say, okay, in what other way can this important new information feed into decision making? The one way that I can see potentially is that in your matter of discretion for a restricted discretionary activity, one of the things that you can consider is the best available information, just simply that. So it's not a trigger for the rule. It's like you've already entered the rule. You're down in your matters of discretion. One of the things that you can consider at the time of decision making is best available information. Then the helpful thing that the Gore Council can do is make visible the best available information either on the GIS information layers, so they're not rule triggers, or by directing people to the ES site if all of the mapping information is there. I just think if we've got an opportunity for that to be sitting on the council GIS system, that would be a lot more useful. So just that.
And what I need to turn my mind to is how that sits in relation to the plan. So if you are considering what goes in the information layers, are you therefore considering an element of the plan that needs to be decided, or are you considering an availability of information which the council can change? And for me, I need to think about that, and I may need to come back to you either in a reply or at the wrap-up hearing, because we've had this conversation around reference to reports. We reference a document in a rule, it needs to be fixed because people need to assess, as at the date of notification or through this process, the potential impact of that document and the rules on themselves. So if an information layer provides council with sufficient flexibility to jump in and out, is it something that this panel should be determining through the plan processes, or is it something that we need to clearly note as being council is sharing this information? And I've given a submission that council can share the information through LIMS and PIMS, and 100% there are other methods of providing information to the community which I do think are things that the council can turn its mind to support these rules and to support the approach that ES is promoting. And again, would just note again that it is not uncommon for district council plans to refer people off to the regional council. I think Mr Osborne can deal with your point in terms of adding in a restricted discretionary matter. I think that's a good one that he can respond to when he comes to present evidence.
So,
In terms of and just thinking about the archaeological layer, so this was a solution that was being explored in the historic heritage hearing because there was visible, available information actually scheduled, and then some questions raised around reliability and things like that. So instead, have an awareness that it exists, that it's there as an alert layer, but that awareness for us that it then is effectively a non-regulatory measure, but it is visible, available information that helps inform decisions so that when we're deciding on the plan provisions themselves, we're aware that there is some information available that can support the framework that we've put in place. I think that's how I'm thinking about this maybe at this point.
My observation is between the two different potential information layers is the archaeological information is probably more fixed in time. It's not something that changes, whereas we do anticipate that there will continue to be evolution of this type of information, particularly, for example, in the end of this year and early next year. So where the archaeological supporting information is potentially slightly more static, I would say this information is much more fluid and much more likely to be subject to change. So that would be something that needs to be carefully considered. But as I say, I do also want to consider those information layers around their fit with this process. I wasn't closely involved in providing legal submissions on historic heritage, so I probably haven't turned my mind to it properly. I apologise if that's an omission on my part.
And what I'm looking at here is the recommended changes to the heritage section and the discussion that it has on the information layer and the way that it links consenting processes. So I think there is a need as part of the wrap-up hearing for you to come back and give us some further advice on that, particularly looking at the recommendations in what I describe as the final version coming from advisors for the heritage section. Now, the second matter I want to raise is that you made reference to the submission of Environment Southland being quite narrow, but when I look at submissions of Environment Southland throughout the plan, and just looking at one here, it talks about zone changes or changes to provisions within existing zones have the potential to intensify land use change and development within flood inundation areas. Rather than looking in isolation at the submission that's classified, which is to one chapter, looking at the plan of the whole, Environment Southland has a whole series of submissions to the zone provisions and elsewhere, saying you need to take into account the potential for inundation when looking at development. So I'm just wondering whether you've gone wide enough in your comments.
And I take your point. There are a lot of submission points of that nature, and I think if that submission was supported at the time with maps and with even indicative maps of the likely modelling, then that would be a much more robust position for ES. But I would, I think I pointed to this earlier when I talked about that overview. So there's an overview issue of scope, and my friend who gave submissions for Environment Southland referred to the fallout of changes to objectives and policies and the ability to seek to make amendments to rules that sit under, for example, a policy, and then changing the rule to fit better with the policy. So if an amendment was sought to a policy, I accept that there is available scope for fallout changes, but that also needs to be quantified by consideration of the specific. And as I've set out in my submissions, maps are a unique beast. They do tend to be one of the places that people look first to see whether they are in or out, or up or down, or what the extent of application of the rules is going to be. So I do think that this information is essential, and it is only arriving yesterday. So, and it is only partial. So again, I return to my submission about how robust it is to give the panel scope to move forward with the proposal.
Okay, but also to us, what's a relevant factor is through all the other hearings where the submission came up in the zones, it said this matter needs to be considered as part of the hazards hearing. So what it was flagging was there was not an expectation that maps or anything else would be presented at the earlier hearings, that it would all come now.
So if I could just return again to the fact that we've heard today from the telcos, and they've engaged with the Section 42A proposal. Mr Anderson reflected upon the assistance that was provided by Mr Osborne on the provisions in the Section 42A report. So can we just turn our minds to how it might need to flow if we were to try and incorporate the new maps and then incorporate some changes to the provisions? We don't have written provisions. We don't have written rules, objectives or policies to support the map changes. So as I understand it, option 2, which is the one that you described this morning, Commissioner Hovell, would require new supporting provisions for the new mapped areas. So that it also requires, just before that, new mapping from Tonkin and Taylor, which I think would probably take at least a month, and they'd be screaming if they needed to have it to you in a month. So in the context of this process, I can't provide a solution for you to fit those further steps in. Because if we are supplementing the Environment Southland, so it would first of all require GDC to undertake the further mapping to supplement the ES position for the rest of the district. We'd need to run that check, which you've already run in terms of the existing ES mapping, just to make sure the boundaries aren't substantially different. So that would be in my submission an essential first step for the further Tonkin and Taylor mapping. Then we would need to develop provisions. Or perhaps we could do that parallel, but ideally we would have all of the information available at the time. The provisions, in theory, might be consulted with or conferred with, developed in conference with Environment Southland. That's 2 or 3 weeks, again with the experts involved screaming, because that's a short time frame in the grand scheme of things. We'd then need to publicise them, because this information and this approach has not been encapsulated anywhere. It's not in the 42A report, and it's gently considered in the supplementary evidence. So this time frame is starting to blow out way past our wrap-up hearing in April, and it's almost looking like blowing out past your end date for decisions. I do accept that Mr. Roy suggested an interim decision. Sorry, I don't accept that that's an option available to you in the context of the current process, because we do have that hard end date of 31 August.
And what is the status of an interim decision, and do people have appeal rights? A minute from the panel can achieve the same outcome as an interim decision in terms of seeking some feedback on something, but you're accepting what you say in the interim decision. I do want feedback from you as well in terms of the changes that have been made to the notified provisions, and I'm looking particularly at Natural Hazards Policy 2, which in its original form talked about managing use, development and subdivision of land in all mapped actual potential inundation areas, with the exception of the stop bank protection area. So there's explicitly provisions in this chapter that says the stop back protection area is excluded from the policies, and the justification for now including rules on the stop bank protection area is that the policy's changed, and as a result of changing the policy, then new rules are appropriate. So in the notified version, if someone picked it up, there's no rules applying to the flooded area behind the stop bank, and now there's rules. If I'd picked up this potentially at the beginning of the process, I would have seen the stop back protection area is excluded from policies and therefore from any rules, and now they're included. So is that a jump? Are you comfortable that the submissions lodge actually gives scope to make what is a 180-degree turnaround?
So we did discuss just a little while ago that concept of an amendment to a higher order provision requiring an appropriate response in the rules sometimes. I would need to look carefully at submissions on this particular provision, and I'm happy to do that in the next wee while. I would like, though, to hear from Mr. Osborne in terms of his planning comments on that question, and then that will give me a wee chance to look at the submissions on this particular provision as well.
The reason for raising it, I can imagine he is saying, well, if you're saying what they're wanting is beyond the scope, then what's in the recommendation to us, likewise, they could be saying, is that beyond the scope? So I think we need to be satisfied that what we've been given here is robust in terms of the legal status.
Certainly, and so I will look at that in terms of that specific change, and happy to do that. So just pausing, so I think Mr. Osborne's made a note of that question. I am at the end of my notes. I may need to just check. So what I call option 1 is the 42A proposal. Option 2 as I understand it, is to add in the ES maps provided and then supplement them with some further work by Tonkin and Taylor, and then also some new provisions.
No,
No.
yeah.
So,
in our conversation with Tonkin and Taylor yesterday, like our anticipation was not that more work be done by them. Rather, the only thing that was asked of them yesterday was to check the difference between their existing course layer and the notified planning maps for extent in the settlement zones. So it was really just work that they've already done and that we think is already there. That was the only thing we asked of them.
And it was to confirm what's in the reports, that they base their information on the historic records, which is what's shown in the PDP.
so I might just need to check that, ask Mr Osborne to also comment on that, but my understanding was that Tonkin and Taylor weren't happy with using that course analysis in the maps.
So in our conversation yesterday, some important things came to us from the experts. So there is a strong level of agreement between the GDC expert, Mr Morris, and the ES experts on the use of the Australian guidelines, that is best practice. Also that all of the information that we have, the cobbled together material that informed the notified PDP maps, the Tonkin and Taylor course mapping, and the best of the bunch is this new contribution from the ES modelling. So we came away with a sense, a very strong sense of the extent to which we could rely on the TNT mapping, and that extent was how well it sits with the notified planning material in terms of historic inundation. So a lot of what was there at Section 32 was really based on observations of areas of inundation. And so really this question of how well does that observed information correspond with the course mapping done by TNT? That's a useful thing for us to understand, and it's probably quite a simple thing for them to deliver back to us. And that gives us a sense of the reliability level of the combination of the notified maps and what the contribution has been made by TNT. So we're not probably seeking to place undue weight on it. We're trying to establish the extent to which these things are aligned well. Yeah.
So probably Mr Osborne can comment on the practicalities of that, and we may also be able to ask Mr Morris to come back if we need to. Kia ora. To comment on that. So perhaps it is time now then to hand over to the council's experts, and then we can address any further issues once we've heard further from them.
And we'll come back to your submissions on earthworks.
Yes, certainly, yes. We'd originally wondered if you might like to speak, Ms Hampson, and then you can get away, but I'm happy to take it in a different order if you don't want to go first. Oh, you're on mute.
Okay.
And I wonder if I could just ask you as well to make sure that you comment on the extent to which you have or haven't considered this sort of option 2 that we've been exploring over the last day and a half.
Yeah, sure. So you can hear me? You can hear me. Thanks for having me back. I just thought I've got a couple of corrections, relatively minor, to my evidence in chief. I was wondering if I could perhaps run through those for you first, and then I'll provide you with a quick summary of the scope of my evidence.
If you, we've got a 103-page document of which your evidence is sitting somewhere in the middle. So if someone can tell me what we can find it. Yeah, I've got it at about near halfway through of the expert evidence. No, that's the 42A, it's in the expert evidence stuff. It's a thick document. We'll share. Natalie, if you proceed, thanks. We'll share document here.
Thank you. So just at paragraph 11, I had the word national, which should say natural hazard. So that's one brief correction.
It's a big paragraph.
Paragraph 11.
Yeah, okay, found it.
And if we jump through to paragraph 53.7, and I can give you a page number, that is on page 18. On the second to bottom line of that paragraph on page 18, there is a word missing, and it should say 73% of all vacant PEC.
Okay.
Paragraph 69, which is on page 24. My evidence was drafted based on rules or drafting of the rules that were provided to me at the time, and the numbering of those rules differed from those that ended up in the Section 42A report. So I guess there's a bit of a key as to how they translate throughout my evidence. Where I refer to Rule 2.1, that is in fact now Rule 3. And Rule 2.2 is now Rule 5. And Rule 2.3 is now R6.
Thank you.
And just jumping to paragraph 72 on the following page, page 25, that list in the first line is, I've repeated R.2 and then, or 2.2, 2.2 and 2.3. That first one obviously should be 2.1.
Thank you.
In paragraph 88 to 92 of my evidence, I provide a discussion around the implication of a finished floor level for non-sensitive activities. And throughout my evidence, that section of my evidence, and also in my conclusion and summary, I've concluded that I didn't feel that the benefits of the 0.5% finished floor level was appropriate for non-sensitive activities. However, I prefaced that section incorrectly, because I had assumed at the time, I'm not sure why, that the recommended provisions didn't apply the finished floor level to non-sensitive activities, and as the Alliance evidence has pointed out, it didn't do that, even though even though my evidence is correct on that point and I didn't support the floor level, I just prefaced that section incorrectly, because the recommended rules were not the same as the operative or the notified approach. So just making that clear. As it happens, Mr. Osborne has accepted Alliance's evidence and submission to make that floor level not required in a restricted discretionary activity, as was discussed this morning. In terms of my analysis or my evidence, what I've carried out in order to inform my economic findings was a detailed spatial analysis that looked at the overlap between property boundaries the notified zone areas and the 3 overlays that were in the originally in the ODP and in the notified PDP. I focused my analysis, so that allows me to, that was done in GIS. It gave me a very detailed examination of individual parcels in each zone and how they may or may not have been affected by the extent of those overlays. So I focused on the stopback protection area and the actual and potential inundation area for my analysis. I haven't given a great deal of consideration to the Mataura River flood overlay. Once I had done that, I have modelled plan-enabled capacity. So plan-enabled capacity, you may be familiar, is really the building or development opportunity on any one parcel according to the planning provisions in those zones. So plan-enabled capacity, if we take National Policy Statement on Urban Development, for example, applies if a house, for example, is permitted, controlled or restricted discretionary activity. So I've worked out what I believe might be the plan-enabled capacity of each of the residential zones in the district. And then I've determined how many of the parcels that contain a plan-enabled capacity or some further development opportunity are located in an area of an overlay. I've been a little bit more specific, and just because a parcel included an area of overlay within the boundaries of that parcel, if there was still a reasonable area to provide a building platform and a dwelling that would sit outside of that overlay, then I've decided that that parcel was not constrained. So I've estimated, I've applied once I've got an understanding of what I think is plan-enabled capacity outside and inside the overlay areas, I've applied the recommended planning rules developed by Mr. Osborne. Notably, they were a combination of either restricted discretionary or non-compliant consents depending on location. Now, I would caveat that my analysis occurred prior to some of the zone recommendations, the removal of some of the zone areas. So, for example, the rural lifestyle zone in Mataura fell within the inundation overlay, and on the advice of Tonkin Taylor, Mr. Osborne has recommended that that not be upzoned in the PDP. That was included in my analysis, so I've considered perhaps a worst case scenario. And there are a few other small instances where some zone changes would remove some of the areas that I was picking up in my numbers. And also further, after I completed my evidence, there was a late change to the general residential zone in Mataura, with Mr. Osborne making that restricted discretionary rather than non-complying, and I supported that change based on the findings of my evidence. So one of the things I considered once I worked out how much of the district's plan-enabled capacity was potentially impacted by the recommended provisions, I considered whether that was going to constrain the district's growth in any way, and concluded that there is enough plan-enabled capacity outside of the overlays to accommodate projected growth, which is a really positive outcome. And then once I've done that, I've estimated for all those properties that are impacted by the overlays and require a consent or would be non-complying, I've estimated the economic costs and benefits to those properties. Overall, I've concluded that the provisions as recommended are efficient and that the benefits would outweigh the costs. I would say that that was quite a comprehensive analysis, and based on some of the conversations that have preceded yesterday and today, if we are pursuing, if council is considering pursuing an option 2 where a planning framework was to be redesigned around these more accurate, well, let's say more detailed risk maps, I would strongly recommend that a similar spatial analysis was carried out to inform that. The reason being, and based on some of the recommendations from Environment Southland, changing the activity status has significant implications for property owners. So if it's restricted discretionary at the moment and becomes non-complying, perhaps if it's in an H3 or above area as recommended by Regional Council, that becomes it goes from that property having perhaps development opportunity to having no development opportunity, essentially, and that creates a significant opportunity cost for those landowners. Under a restricted discretionary consent, they can still realise development potential, but in a way that makes them resilient to the effects of flooding. So there is a significant difference, and I would strongly recommend that it is scrutinised through a proper analysis before those changes are made, because the decision on whether it's H1 and 2 becomes restricted discretionary or H1 to 3 makes a significant difference. For example, in the Stockbank Protection Area at the moment, largely that area is H3, and if that was the threshold at which it became non-complying, that would rule out almost all development capacity in that part of the overlay. So those things, I believe, need to be properly quantified. The other main thing I wanted to talk about this morning was just, as I guess, a bit of a caveat to my analysis. I have considered the compliance cost of achieving a 0.5% finished floor level. However, I've done that without knowing what those floor levels actually are. So that mapping information was not available because that scenario hasn't been run by the Regional Council. I have approached my evidence on the basis that Tonkin Taylor had indicated that they thought that the floor level proposed would mitigate the risk of flood damage for those buildings in most cases, and that there are construction methods that would allow, different floor level heights that people could adopt. So whilst I've made conclusions about the economic effect of the floor level, I would say that it's still not certain exactly what that looks like, and I don't know, that will vary from property to property. And somewhat related to that, and it may be relevant, or something I guess that's just been sort of hanging over me throughout this process, is if Environment Southland do map the 1 in 200 flood event, does that become an information layer for the community? I think there was discussion yesterday confirming that the planning provision should be developed on a 1 in 100 flood event, and we have a broad understanding of the extent of that flooding because it happens to relate quite strongly to the current overlays. However, there's kind of a perverse outcome I'm a little bit concerned about, that if, depending on the activity status settings and the floor level requirements within those overlay areas, what that effectively does is encourage housing development and development sensitive activities to locate and zone areas outside of those areas, because that's where it would be a permitted activity. They wouldn't need to meet any floor level standards. They wouldn't require a consent, potentially. That's the way the rules work at the moment. And that's a positive thing. It's encouraging development to occur in areas not affected by flood risk, but it's only encouraging them to be outside areas affected by the 1 in 100 flood. So if there was a 1 in 200 flood event, under the current recommended provisions by Mr. Osborne, any new houses that were in the overlay would be resilient to that flood, presumably, because they had a floor level that was above the 1 in 200 flood event. But for all of that development that was encouraged to locate just outside the boundary of the overlays, they have no protection from a 1 in 200 flood event. And so on the one hand, we're encouraging growth to go outside of that boundary, but we're not offering them any protection. So I just worry sometimes, or perhaps don't understand, that disjoint between basing a planning provision on a 1 in 100, but basing a floor level on a 1 in 200, and perhaps where that has come from, and if there are any unintended consequences for the community from sort of taking that very precautionary approach with the floor level, because it does make development more expensive, and that might encourage people to develop elsewhere, but similarly with no protection. So that's just one thing I wanted to flag, because it's something that has perhaps sat a little uncomfortably with me the entire time.
So are you ready for a few questions?
Absolutely.
Cliff, anything? Dennis? Maria?
Kia ora, your evidence is, you've well laid it out for us and it's very helpful, and we take your point in terms of the detail that's gone into that analysis to help us understand the impacts, and that is the detail that would be expected if there was a shift in the way that's been talked about. So definitely understand and take your point very well. So I wanted to explore, my worry at this point is we've got actually agreement between the experts, Mr. Morris and the ES experts, that definitely H4 and above is, we should consider, it's significantly harder to make new sensitive buildings safe. So that doesn't seem to be in dispute. So the only area where there is a bit of prevarication is around H3. So if we imagine that H3 remains in the restricted discretionary camp within the stop bank protection area, that sort of narrows the focus of this conversation to what happens to those H4 areas. And so what you were saying before around the stop bank protection area largely having H3 in it, I think it's close to true. But when we looked at the maps provided yesterday, we could see there is some H4 land in there. And this is the thing that I guess we're grappling with, is that is representing a risk level to those property owners. And we're thinking about things like they make use of the permitted activity to put a granny flat there. So, you're introducing a new vulnerable person into what our experts are already telling us and agree is a high risk area where sensitive activities should not be encouraged to further intensify. So that risk component, by enabling further development in that H4 land within the stop bank protection area, that's a key consideration for us, and so we're understanding the economic implications that you're bringing in terms of constraints for there's a cost there, there's a constraint, but equally there's a cost to being unprepared for a high risk event. We've also had evidence from ES that at the 2% AEP, there's breach potential, but at the 1% AEP, there's guaranteed overtopping, i.e. the stop bank does not protect. And that's what's really top of mind for us in trying to understand the implications, and what you're bringing is that analysis of the difference between the economic impact of the constraint and the economic impact of not applying a suitable constraint. So is your answer effectively the one that you've already given, which is if we are going to get in any way fine-grained about thinking about those H4 properties, that's where you would expect this additional detailed analysis to occur?
Yes, absolutely. And I've got it on my screen at the moment. I have the flood maps from Environment Southland and GIS, so I'm able to zoom in very close and look at property boundaries and where there's buildings already. And I'm happy to show those to you if that's helpful. But so what you would want to do is you would want to tag properties to each of those H1 to H6 within each zone, and so that you could understand how many property owners were affected, and then you could start testing the implication of different activity status. So I would agree, in the stop back protection area, there are areas of H4 and small pockets of H5, although mainly limited to the roads or in the park. So yes, mainly there are some areas of H4 that would need to be, I guess the impacts on those property owners would need to be considered.
And part of our conversation yesterday was also an awareness that there is some new development happening within that stop pink protection area now that has been consented, and that will not be guided by what we're talking about here. So it's a very real prospect that between our decision and any future plan change that might properly address the information coming from EES, that further development may occur. So we're very mindful of how we can do our best in this process to not exacerbate that situation, which is already occurring. Yeah.
Yes, I agree. That I think the real question is, what is the risk for the council of pursuing with option 1 in the interim of before a comprehensive plan change was developed? And I think to understand that risk, you need to understand both the effectiveness of the recommended provisions to manage risk for most properties, particularly H3 and below, with a floor level of 0.5. And also the number of new dwellings that may be expected to occur in that time frame. So across the whole district, according to projections that have underpinned the PDP, we're talking about 27 to 35 dwellings per annum across the whole district. Now, certainly only a portion of those may want to occur or be likely to occur in what is currently the stop bank protection area. So even if they all occurred in there, you know, it helps you get an understanding of the scale of the risk that may occur. And I would argue for, except in those H4 property locations, the requirement as recommended for a floor level of 0.5 AEP would probably be very effective. And I think you made a point earlier that having this information layer, the 1 in 100 maps available somewhere, whether that's on Environment Southland's websites or the council's GIS, and as Shelley was saying, maps are very powerful tools, and if someone is considering, heck, I might put in a granny flat, or I might consider an alteration to my house or build a new dwelling out the back, if they find that, look at these maps and see that they're in H4 and there is some education around how they are meant to interpret what H4 means for them, you may well find that you know, people change their behaviour and they may not pursue development. So I do think it's very important that these maps become available and that they're explained appropriately to the community in the meantime.
Is there a corollary to what you just said that's very helpful in terms of the scale of risk that you just shared? I think that's extremely helpful. The flip side of that too would be that's the scale of the impact of constraint, is it not, as well? I.e., if we were to move towards option 2, does it tell us that actually the impact of moving towards option 2 is a similar scale of impact? It may be 1 or 2, you know, over the life of the plan until a plan change occurs, and that we are anticipating that a plan change that occurs will bring this in, because it is the best available information. So we've got no reason to think that it wouldn't.
You're partly correct in terms of perhaps. Well, the reason I say partly is because an opportunity cost, if the new provisions came in and said non-complying in H4 and above, and let's say that affects 100 properties in the stop bank protection area at the moment, they face an opportunity cost irrespective of whether they were planning, you know, and those properties had some form of additional development capacity, like space for a granny flat or an extension or a new dwelling. they face that opportunity cost or that loss in property value, irrespective of whether they were going to act on that opportunity or not. It is a reflection on what can be achieved on their property, and that is reflected in the value of their land. If it is a vacant land parcel, and again, this is something you could pick up in the analysis, if there are vacant parcels in those H4 and above areas that have not yet realised the development potential of their land, their opportunity costs are significant to take that away. And there is good reason for that, and there are benefits to doing so, but you would still need to understand how many properties are potentially affected by opportunity costs.
Yeah. So, and I appreciate everything that you just said. So, what we've been talking about is a variation that brings the maps in as a plan change, and we've got no control over that. When it happens, if it happens, we would most certainly hope that it would happen, because this is the best available information, and this is intended to protect resource users going forward. Is the to what extent should we bear in mind the potential for change in this material that's been brought to us? So one thing we know will change is it will extend across the district, and it only does Gore and Mataura at the moment. We've got some indication that the hydrology might improve, and they might bring in climate change impacts as well. So there's that. Is there potential for, further movement in this, another relevant factor, i.e. at the time of a future plan change or variation, further refinement may have occurred, further properties may be affected beyond what we've got at the moment. And I think the advice that we've been given is it would never go backwards. It won't go backwards and tell us that an H4 is suddenly not an H4. What it's most likely to do is expand the number of properties that would be caught. And so thinking of it like that we, from the information that we've got now, it will only capture more properties and not go backwards. How could we think about that?
Yes, and I think that's why you do the spatial analysis once you've got those final maps, not before. I think if the maps keep changing, that creates a bit of uncertainty for the district, but I think that's possibly an unavoidable risk. I'm a strong supporter of the best available information and best practice science being applied to all planning regulation. And if it means that, I think it's about how you communicate that effect to the residents and say, look, these are the maps at the moment, they are being updated, but this is for your information now, and you can expect an update in a year's time. I think residents would respond probably to have some certainty around that. Any economic consequences of perhaps highlighting that they're in an H4 or above area, and perhaps signalling that that might not be a place where they can develop in the future, you're really just bringing forward those impacts a year in advance. I would say that it's a temporary cost, and probably I perhaps wouldn't wait a year, is what I'm saying, necessarily, to show them this information, because the market may just regulate itself and go, well, I might just wait and see rather than build that house tomorrow. Yeah.
Can I just, in terms of the economic costs, take you to what was notified as Rule 2 and it's now proposed as Rule 3? And what was notified was that buildings for sensitive activities within the area of actual potential inundation are permitted, provided that they meet the 1 in 200 year flood design.
Yes.
And that rule didn't apply to the stop-back protection area. What has now been recommended to us is that the stop-back protection area now be included in that rule, so if you don't meet that design. But more importantly, the rule has changed from any new building or building addition to only allowing building additions within the area's actual and potential inundation. So the additions are permitted provided you meet the 1 in 200 year flood design. It now includes the stop-back protection area, but also there's another clause saying no additional residential units are created. And if you want an additional unit, such as a secondary unit, which was recommended to us as a permitted activity in the residential zone, that now becomes non-complying. And to me, that has some severe economic consequences for property owners within the affected area. So from an economic point of view, what is your view?
So I did assess that rule as it is drafted before you. So that is what I've considered in my evidence. What I think it means, it doesn't become non-complying. If you're wanting to add an additional residential unit, then you default to either R5 or R6, and it would be restricted discretionary.
Well, I'm looking at...
I'm happy to clarify that if you'd
Yes.
like me to.
Yeah.
I was itching to jump in there. So, and this will, I can clarify this further as I step through the 42A next. But yes, Rule 3 is addressing just the issue of additions and alterations to existing buildings. The reason it specifically excludes residential units there from consideration under that rule is for the reason that Ms Hampson has outlined, is that new buildings within that area are addressed under Rule 5.
So why are they in Rule 3?
They are addressed separately under Rule 3 to ensure that there's no sort of loophole created where an additional unit is created through that extension and comes through at a permitted activity level when it should be treated as a restricted discretionary.
So the effect of that is that a granny flat separate or attached to an existing building is a non-complying activity.
A new building should be treated under Rule 5 within that area. And if further clarification within that rule, is necessary to ensure that that's clear, then happy to pursue that. But that is the intent.
And so R5 would make it an RD with a minimum floor level that's raised or non-complying without that.
Correct.
For the granny flat.
So the addition to the building has to be raised up above the floor level of the existing building.
And this comes back to evidence from Tonkin and Taylor in terms of risk to life and risk to occupants. So it's addressing that particular risk. Some plans require it and some don't. Moreover, in the South Island, you see this as a common rule. It would be a permitted starting point for an addition and a minimum finished floor level above a certain identified height.
Okay, so back to Natalie, what regard have you given to the additional servicing costs to construct infrastructure if we're providing for further residential development outside of the developed areas?
I've only considered, are you talking about directing growth or encouraging growth to occur outside of flood areas?
Yes.
So I've only assessed, there is plenty of plan enabled capacity in your zoned areas outside of the overlays. So I don't believe there is there will be no driver to encourage more development beyond the zones that have been provided in the PDP, because there is more than enough zoned capacity to accommodate growth over the life of the plan. So I presume your zoned areas either have or will be planned to be serviced with infrastructure.
Thank you. Maria, anything else?
Look, I think that's been enormously helpful, and I particularly appreciate your consideration of the idea of temporary cost, because I think there are a number of implications that we have to consider. One of them is process and natural justice related, which I believe our legal counsel is drawing our attention to. And within that picture is also this basic cost benefit analysis that guides us as well. Yeah, so I absolutely appreciate your evidence this morning, and particularly your note that should there be any movement, that additional spatial analysis would be required. Kia ora.
So thank you, Natalie, for making yourself available. You have triggered a question I want to put back to Marcus, and that's in terms of whose responsibility is it to actually publicise and give some wider sharing of the information that Environment Southland has now. It appears to me that it's probably the responsibility of ES to populate that, yeah.
Thanks for the question. I was just looking at the regional policy statement for methods around this very issue, so very much answering it as I'm trying to read. But ultimately, I would say that effectively it's a joint responsibility, regional council and district council. I guess promotion of the rules and the zones and natural hazard maps within the district plan, help understand that and articulate that during LIM reports and PIMs and that sort of thing, but also in general flood management, our regional council should definitely be communicating that risk, etc. as well.
Is any publicity proposed?
Yes, there is. Yep. Once we get through this process, then we'll be working through continual engagement on the flood mapping throughout the region. It's not just Gore and Mataura townships. It's effectively all catchments as the modelling rolls out over the next 2 to 3 years.
So you say when we're through this process. So does that mean that decisions come out really for many people will announce what you've got, or are you talking about ES doing something before the 31st of August?
So Environment Southland has got a communications plan associated with the flood information, and we'll be working to roll that out in due time. I'm not sure exactly what that time frame is, but I would anticipate it would be well ahead of decisions on the PDP.
Yeah, I probably see it as from a process point of view, something quite important, because I think in some respects it's probably not fair on us as a panel if we're the ones that need to explain what's there to the public. That information really should be out there so that there's awareness of it. It probably makes our task of writing a decision a lot easier. So I guess our expectation is Environment Southland will be doing something before the decisions are released, and we really need to know otherwise if that's not the case.
Certainly.
Right, back to the team opposite. Who's next? Yeah.
I just want to have a quick catch up with Mr. Osborne on something I may or may not have said incorrectly. So I just want to clarify with him.
We've been going for an hour 20. Should we take a 12-minute break?
Yeah, is that okay?
Yeah.
Thank you so much.
12 minutes.